I'm going to call House Judiciary to order. We'll take attendance, Madam Clerk.
Chairman Phillips.
Yes.
Representative Mueller.
Here.
Griffin.
Here.
Johnson.
Here.
Colley.
Here.
Brendan.
Here.
Berman.
Here.
Clemens.
Here.
LeGrand. Yancey.
Here.
Bolden.
Here.
Hope. Here. Green. Mr. Chair, you have 11 members present. You do have a quorum.
All right, I have a motion from Vice Chair Mueller to approve and adopt the minutes from the previous meeting, April 12th. That's great. I don't think he'll have a problem. Get on your way. We also have it.
Yeah, with attendance and Mueller.
All right, so first on the agenda is a presentation from SCAO, Administrator Tom Boyd and Cami, regarding a proposed rule change regarding remote hearings. Now, during the pandemic, of course, there was a lot of upheaval in the justice system, and to keep the ball rolling and protect the public health and safety, many aspects of the court process were used remotely. So we understand it. Pandemic has changed or slowed down or whatever you'd like to say. However, there is a proposed rule that is going through the rule process at the Supreme Court level that would essentially extend some of those changes, and the rule has been provided to the committee, and I believe we're providing it right now to the Republican side. And then throughout this process, I've also read an op-ed in the Detroit News from 2 Supreme Court judges who are pushing back against this rule. And so I think I see this as more of an informational hearing to hear SCAO's reasoning and maybe what goes into it. And I do believe that we're in the public comment portion of the rulemaking process, and so I think it's important that the public knows about what's going on. And I do believe there are some questions about, whether access to justice and fairness throughout the court process matches up with remote hearings. And so, a little bit of a nuanced issue, but Tom Boyd, whenever you're ready, I just ask that you announce yourself and your role, and we'll go from there.
Morning, Mr. Chairman, members of the committee. Tom Boyd, I currently serve as administrator to the trial court system. Thank you very much for the opportunity to provide background information about the history and the future of remote proceedings. And we're always happy to take input from stakeholders such as yourselves. I do need to just emphasize Chair Filler's points a little bit. As the pandemic took hold and different institutions ended up closing the doors, Michigan transitioned to remote proceedings much more quickly than most of our neighbors and most states in the country. And that is because of investments that your predecessors and mine made in monitors and cameras in courtrooms. So you've been in courtrooms, you've seen video arraignments and other things. We've had cameras in every single courtroom for over a decade. And a part of our business has been remote I became a judge in '05, and already remote proceedings were ensconced in what we did. The big important pivot for Michigan was that in May of 2019, the Supreme Court provided every judge a Zoom license before most of us knew what Zoom was. And that's not because of a pandemic. Obviously, we didn't know one was coming, but it was because remote proceedings is a key to access to justice and efficiency. So during the pandemic, we had over 5 million hours of hearings on Zoom. The virtual courtroom directory on the Supreme Court's webpage has been used more than 485,000 times. We have 196 local trial court subscribers to local trial court YouTube channels, and millions of YouTube views of trial court proceedings. I think it's important to note that during the pandemic, the Supreme Court, the 7 justices, had 20 consecutive unanimous administrative orders to create and put up the pandemic structure for proceedings in court. Almost all of those have been rescinded. There's a couple key that have not, and many of them in July of last summer were rolled into a court rule. So I think the thing we're talking about is a proposal is really the law today. It's really the rule since July 21st, 2021. There are 5 specific orders having to do with sort of creating this remote procedure and maintaining it and tweaking it. I'm not going to go through each one, but I'd be happy to discuss any of the details with any of you at any time. Significantly, those orders were shaped by lots of input. First thing we did in early 2020 was form the Virtual Courtroom Task Force, which was chaired by Judge Kathy Viviano from Macomb County. And a large group of stakeholders got together and said, okay, we're going remote. What does that mean? What do we do? From that, created voluminous guidance, all of which is available on our webpage, to trial courts to talk about what does it mean. Everything from very detailed technical aspects of operating a Zoom proceeding, recording a Zoom proceeding, maintaining a verbatim transcript, all the things that courts do in the in-person space, in the brick and mortar space, how to do that in the remote or the virtual space. All of that came from the first task force led by Judge Viviano. Really significantly, the next group we put together was about remote jury trials, and that was led by Judge Carl Marlinga from Macomb County and Judge Aaron Gauthier from Presque County. And I say it's significant because tons of energy went into that experiment, and it showed that that fully remote jury trials was not really for Michigan. They went through an entire pilot project, a mock jury trial, and they all concluded that this isn't probably where we want to go. And to date, Michigan has had 0 fully remote criminal jury trials or any fully remote jury trials. So we tried some things, and they worked real well, and we've succeeded and are on the cutting edge, and we've done other things that really didn't fit for Michigan and we haven't pushed forward with. But I think it's important to note that both of those things shaped what became our remote footprint, our virtual footprint. Almost simultaneously, kind of like about a month, 6 weeks behind, we created 2 groups to look at today. So we're talking about spring 2020, knowing the pandemic wouldn't last forever. What do we take from it? The 2 groups were the Lessons Learned Committee, chaired by Judge T.J. Eckert from Kent County Probate and Judge Patricia Frizard from Wayne Circuit. And their job is to take 2 questions. One is, were we prepared for the pandemic? And what do we need to do differently to prepare better in the future? And what have we learned from the pandemic taking us forward? What will stay when the pandemic's over? And much of what we want to talk about today is from that group. The second group is the Task Force on Open Courts, Media, and Privacy. And the question is, what that happens in a courtroom is really okay to be broadcast to the world? So our courtrooms, not only in Michigan but in the country, have been public since, the creation of the Union. But there are things that happen in courtrooms every day that we really don't want broadcast on the news, that we wouldn't be comfortable with kids at the lunchroom in the high school watching and talking to their friends about. So when we transition from in-person live public in a brick and mortar space to live public on the internet, we had to really wrestle with what does it mean to be public? And that group has made some recommendations we'll talk about a different day. But it's a complicated question, and I think we'll eventually be working together with the legislative branch to talk about. So, for instance, there's a very detailed statutory framework for a vulnerable witness or a vulnerable child witness. And what do you do and what factors do you evaluate before you lock the door? And, of course, in the brick and mortar context, that's a key in a lock, and you lock the door. And what do you do to take down a YouTube stream? So those are conversations we'll kind of have in the future. What we're working on today is what is it the proper balance between a remote proceeding and an in-person proceeding going forward. The rule that's in place now that I believe just has been provided to you by Mr. Capone is always been an interim rule in its own terms. The court comments, which is very rare in a rule, that is an interim rule, and we'll see where we go next. Well, that's where we are at this point. Where do we go next? technically, the public comment period has closed on that, but anytime you want to provide comment to us, it's always going to be timely. And whatever the court does next isn't going to be the last thing the court does. This is something we're going to continue to grow and evolve over long periods of time. But just some of the things I want to share with you as it relates to the information gathering that the court's been going through over the last, certainly since July 26th of 2020, but really over the last 18 months or so. Literally thousands of people and organizations that they represent have weighed in on the issue of this administrative file and proceeding with remote hearings. In fact, it's safe to say that this issue has received more public comment than any in the past few decades. Nearly 40 individuals and or organizations provided comments by email to the Administrative Council, 130 submissions to the Lessons Learned report, 54 comments received to the Task Force on Open Courts report. Nearly 1,900 people participated in a survey, participated in more than 100 stakeholder meetings. So in July, when the court issued the interim order, it dictated that every chief judge have a community meeting to hear from their community stakeholders what's working and what's not working. Each of those chief judges were then tasked to provide a written report back to the court about what they learned from their stakeholder meeting. So we have literally every single court providing a written response from their community to the court about what worked and what didn't work. 65 individuals actually participated in providing public comment at the public hearing earlier this month. Just a few highlights. We've learned that going back isn't really an option. You know, not one of the people who has provided comments so far wants to return to a situation where we don't have remote proceedings. The question is, what type of remote proceedings will we have? We've learned that from the bar that remote proceedings make attorneys exponentially more efficient, in part because they're able to appear remotely at distant locations, two different distant locations on the same day. In particular, this benefit is particularly profound with legal aid attorneys and their clients, allowing a marked increase in access to justice. We learned that the public is benefited by the convenience of remote proceedings, no more taking a day off work, getting daycare, paying for parking, and appearing in court for a very brief hearing. You know, my rule of thumb has been if it takes you longer to park and come through security than the time you're in front of the judge, we did something wrong. That was a hearing we probably should have considered to do remotely. We learned that there's a challenge to dignity and decorum in the courtroom, and judges have had to learn on the fly how to accommodate with bad behavior. You can't simply say the fellow with the gun behind you is going to take you away now. You have to use different tricks and different technology, and the trial court judges have responded with creativity and diligence to create that new framework. Now, on a converse point, we hear, especially from family lawyers, that the public, especially children, are much less intimidated in the remote setting and much more likely to participate in their own hearing. We learn that technology doesn't work every time, and that many litigants don't have the know-how or the economic capability to use it. But these problems are solvable, and we need to create exit ramps so people can appear in person if that's what's appropriate. Finally, we learned some things that we kind of already knew, and that is that many proceedings are not appropriate to be conducted online. In particular, every order that the Supreme Court has issued has always said subject to constitutional rights. There are certain folks who have constitutional rights to not only be present, but to have everyone else be present. And so the idea of a remote proceeding is never going to run foul of that standard. So the challenge moving forward is, how do we balance the goals made clear by all of this public comment to continue access to justice through predictable use of video conferencing technology and the judicial discretion that's needed to make sure that we're setting the proper environment for those proceedings. As we consider the path forward, we must focus on who benefits. And from our perspective, it has to be the public. The system we adopt going forward must start with and end with what's good for the public. So I really appreciate your interest and be happy to answer any questions. I have lots more data and interesting, but I'm not sure exactly. I want to be respectful of the committee's time. I'm not sure what would be responsive to your questions.
And you know, because I don't wake up every morning and want to go and read public comment or sit through public comment, or because I sometimes don't even know it's ongoing. Sometimes this is a little bit of like a sunshine, putting sunshine on proceedings. So you mentioned that there was some pushback. You know, I read the op-ed on the Detroit News about pushback from victims groups and from trial judges. I mean, can you explain what that pushback was? We weren't probably there to view it, so I'm sure with the judges, they don't want, some judges want, I guess, more discretion than the rule gives them. They feel like maybe they're being pushed into remote hearings, but maybe you could just speak to that opposition.
I can't, I mean, I'm not sure I would attempt to voice the voices of others, but I can tell you that in 2020, as part of our work on lessons learned, we worked with professors at Michigan State University, and we conducted a survey of Michigan judges. About 200, about 40% of the judges participated. And the general agreement was that the virtual courtroom makes it easier to participate and access the courts. 94% of the respondents were willing to continue to hold non-evidentiary and motion hearings online after the pandemic. In that survey, judges rated their own performance as being extremely able to accomplish their responsibilities, but only moderately able to maintain order and decorum in the courtroom. Again, as I mentioned, one of the challenges is people are less respectful and need to be handled in a different way to maintain decorum. Simultaneously, in preparation for proposing rules going forward, the Michigan District Judges Association conducted a survey of its members, which about half of their members, about 125, participated in. 90% intend to continue the use of expanded virtual technology for certain types of proceedings. 84% reported that over the past 18 months, meaning while this interim rule was in place, the respondents had found a community-appropriate blend of in-person and remote proceedings. So I'm not sure who's proposing all-or-nothing solutions. It isn't us, and I've actually not heard anybody who has. There aren't all-or-nothing solutions here. What we have to do is to find the blend of remote proceedings and in-person proceedings that is appropriate. We need to empower judges to have the discretion to decide this one needs to be in person. Judicial discretion is a tricky thing. Judicial discretion does not mean the right to be arbitrary. It means the right to make a decision based on stated goals and rules that you express on the record. Because the only way to curb judicial excess is through appeal. And on appeal, the lowest level of judicial review is abuse of discretion. And you cannot judge on appeal whether some judge abused his or her discretion unless there are standards in place. So the question becomes, what standards? Rule 4.206 and 2.406 and 2.407 have been in the rules for a long time, and they have to do with the types of things that the judges should consider when letting someone testify. Honestly, when the rule was written, it was by telephone, but we've advanced far past that. So what do we do with the existing rules to help judges make those decisions in a way that we can make sure that the people are protected from arbitrary treatment?
Rep. Johnson.
Thank you, Mr. Chair. I've got several thoughts and questions, if I may. So this is a topic that I find very interesting. I actually have a bill regarding this in a different light regarding tax tribunals. And basically what it says is if all the parties agree, they can do the hearing virtually, all right? That way, if you got a minor tax issue you're trying to do, you don't got to drive from the UP all the way to Lansing to resolve it, as long as everyone's good with it. That's kind of been my sticking point, is all parties have to agree. So let's say you've got a scheduling conference, right? We're just trying to schedule this out. It would take more time to park and walk into the courthouse than that takes. My guess is both sides and the judge are going to agree. But when there's other cases where maybe one side says, hey, I'm fine being virtual, but the judge or the other side says, no, I'd like this to be in person, I think that right needs to be, I think that has to still be available. I mean, that is what we're used to. That is the ongoing process right now. It does work. So what's your thoughts on the fact of, as long as one party, whether it's the plaintiff, the defendant, or the judge, says, hey, we have to be in person, but if all three are in agreement, hey, we're going to do virtual, then we're good. I mean, what's your thoughts on that?
first, I appreciate the tax tribunal example, because early on in this process, the department that does the administrative hearings invited us in to talk to them about what we were doing, to make sure that they were, using the same technologies, the same lessons that we had learned. I can speak for myself and the recommendations that I'll be making. I believe it has to be the judge that makes the final decision. And I'll tell you a quick story, Representative, to make the point. I was having brunch with some old colleagues from the Department of Attorney General, two of whom are affiliated with, some of Michigan's major law firms. One of whom is a transactional lawyer and one is a litigator, civil litigator. And the question was, well, should agreement be necessary? And the litigator was smiling as big as a Cheshire cat, and the transactional lawyer said, I don't get it. And I said, well, I'll tell you what he's thinking that he won't say in front of me. Parties with money want to be able to force parties without money to travel and attend proceedings, so they will not agree. But they're using that consensus requirement to take advantage of a party with less money. So we want to protect against bad behavior across the system. And that's why we have to entrust the judges to make that call. So if the one party won't agree and their disagreement is reasonable, the judge would make a record based on the standards and say, this is why this is going to be in person. And we can all see that, it's on the record, and there'll be a right for the other party to review it. And so simply one party just saying, no, I think we should be in person, no explanation, no review, it's going to open the door for parties with money to take advantage of parties who can't really afford to pay their lawyer to travel and to wait in court.
Yeah, so counter and say that is the current practice today. Is before the pandemic was that's what you were doing anyways. I guess I think if the defendant says, hey, no, I want to be in court, because there is something different about being in person. I know as someone, I chair the oversight committee, we've had hearings where people testify in person, you have hearings where people testify via Zoom, and it's very different. And this goes to another question I had regarding depositions and how this would affect that, because I was talking to someone in the legal field. Used to be, deposition, you'd be in person. Now a lot of it's via Zoom. I said, you could sometimes tell, right? You're going through a line of questioning with someone, and sometimes you could tell the way they shifted or whatever. Oh, you just touched into something. I need to kind of follow up. So when you're in Zoom, you don't have that same feel, and so you're not able to tell quite as well what's going on there. And so I think that's why there's distinct value in having in person if someone wants it. Now look, if they're all saying we're in agreement, we can do virtual, but if there's someone that says, man, I want to be in person here, because we can read each other a lot better right now than if you're on that television screen. And I don't want to get into a case where you're letting the judge just make the call, where the judge can say, I don't feel like having these people in my courtroom. Sometimes that's more problematic. I got to deal with people. They can cause issues. It's just easier that they're there. I don't think that the motivation is necessarily going to be as noble as it should be from the judge's perspective. And I still go back to, if the defendant wants to be in person, I think they have that right.
Well, a couple things. First, using the word defendant, and if you're talking about in a criminal case, the defendant has a constitutional right, which trumps all of this conversation. So the answer to that is absolutely yes.
I'm thinking like a civil case.
Sure. I have not heard anyone propose a standard where testimonial things would be, even presumptively remote. So again, we have to talk about what types of proceedings. So if you're talking about questioning and reading the questioning, those things are going to be presumptively in person because we're taking testimony.
The question is, if laws on depositions?
Depositions. None of these rules have anything to do with depositions. So I'll come back to that part of the question if you don't mind. I'm sorry, Representative, I didn't mean to cut you off there. I'm just saying that the question about whether or not a scheduling conference where nobody takes any testimony and the client doesn't even talk and the lawyers say to the judge, hey, next Thursday's good, and the judge says, I can't, I'm busy. How about next Tuesday? That conversation today happens in person. And are we all better off by saying, hey, unless there's an exceptional reason to do that in person, we should probably do that remotely? That's really what we're talking about. We're not talking about, again, I made the point that we had a big group got together and said, can we do jury trials? And they just said, no. And as a result, we haven't. Can we do complicated evidentiary things? They're doing it in arbitrations having to do with, finance industry and things like that. But we're not doing it in Michigan civil courts by and large. So I think that we have to separate about what types of proceedings we're talking about. Again, longer to get through the door than to have the proceeding, versus that I want to see you testify kind of a thing. And so what we need to do is we need to separate the proceedings out first and then give different people. So I guess I would say to you, Representative Johnson, that I may not disagree with you, that if we're talking about taking testimony or presenting evidence, that everybody should have to agree. The question is that the same as the quick hearing?
Right, and jury trials better always be in person because you want to make sure that they have to be focused. If they're at home, they're going to be distracted. But I go to the scheduling conference, and I think 99.9% of us are going to say that should be done virtually. It's going to be a whole lot cheaper, a whole lot easier. It sounds to me like your suggestion is that perhaps in a case where there's someone with little money and someone with a lot of money, that the person with a lot of money is going to say, oh, let's just keep doing it in person to try to bleed the other person dry, essentially, from a financial impact. And that would be the only reasonable explanation other than there's a good reason. To which I guess I would counter and say, even in that situation, obviously there's always exceptions, but most lawyers are trying their best not to piss off the judge. And if it's a clear situation of that's what you're going to probably be doing by that, I think the lawyer in that case is going to be incentivized to not be too unreasonable in that regard, right?
Depending on what the lawyer thought the judge really preferred.
Okay, that's fair.
Yeah.
And one final point, if I may, Mr. Chair. During the pandemic, when we, that 1945, 1976 law that we had sued on, the emergency powers, it was on I think it was the Court of Claims decision. We heard both sides give their case, and it was on YouTube, and tons of people watched it, and that was a great thing. I thought that was fantastic, that people could actually watch different issues, and you could hear both sides arguing why the 1945 law wasn't constitutional or was constitutional. I think we need more of that. And so I guess my question is, today with the Michigan Supreme Court, how many of those hearings are being live streamed on YouTube that anyone could watch?
The Supreme Court's hearings, all of them are. As a matter of fact, I think they're having a hearing in just a few moments from Hillsdale College that's streaming.
Good.
So that's a great point, though, Representative Johnson. So Circuit Court Judge Paul Stutzman from St. Joe County tells a story about how, he called a case, People versus Jane Smith, and there's no answer. But 20 minutes later, Jane Smith walks in the door. Well, why are you here? Well, my brother-in-law heard my name called on YouTube, and I wasn't here, and I don't want to get arrested. And so this is happening, that the community is helping us out by watching YouTube and finding out who is missing. I mean, it's become in some communities the same thing as the police scanner running in the background. And again, that's one of the reasons we have to be extra careful what we put out there. But the community is tying in. I mean, you know this from going door to door. I never was more engaged with people than going door to door and having them ask questions about the city council meetings, because those are live streamed. And so they know all about what's happening at the city council. They don't know anything that's going on in the courtroom, at least not until the pandemic.
Representative LeGrand.
Thank you, Mr. Chair, and apologies for being late, Judge Boyd. So I want to just tease this out a little bit, and I think focus in on and resonate some of Representative Johnson's concerns. I think there are two things that are in tension for me. One is what we might call a compelling state interest, and the other is analogizing off of the Sixth Amendment. And I understand that the Sixth Amendment only covers criminal cases, but it's a useful framework to think about this issue, and it seems to me. So, we don't always, in all circumstances, allow the right to confront an accuser. I mean, we even do carve out in-camera hearings potentially, or anonymous hearings in cases of, children can sometimes testify in hearings, not have to face the person that abused them. That's a compelling reason in that case. In this case, I'm struggling to see why we have a compelling reason to say that individuals can't assert their right to direct face-to-face communication. In other words, Representative Johnson's instinct, I'm sort of with him on the instinct, which is, if we're all going to get along and we're all going to save time, we're going to do that. On the other hand, if one person legitimately thinks, and I can imagine virtually anything. I mean, maybe if you and I are scheduling going out to coffee, there are things I could read in your body language when I ask you that question, like, oh, I'm really sick of seeing David, that might, that I might not get in a Zoom call. So I can imagine that virtually every stage of communication, face-to-face might be something that someone rationally wants. And I get that judges can decide under your framework, but at the end of the day, the question is who decides? And I'm not sure that I'm comfortable walking away from. I'm a great believer in the richest form of communication possible. I think that 90% of our problems in society are caused by bad communication. And one of my mantras for my staff is, a text is the lousiest form of communication. Email is the second worst. Phone calls are the third worst. Zoom is the fourth worst, and the best is face-to-face. There really is. It is the gold standard for communication. And so, I'm just generally concerned, and I'm not sure that you've sort of met my hurdle on that. The other thing that I'd say is, I understand your point, but I think about whoever's richest gets to exact costs by making people show up in person. I think there's a potential flip issue, and at the risk of sounding like I'm a Republican, one of the drums that Republicans have been banging for 20 or 30 years, and I think it's vastly overstated in general, is the idea of nuisance litigation. However, the easier you make anything, the more often people are going to do it. So if you said that all I had to do is get out of a parking ticket was raise my right hand on a Zoom call, I'd raise my right hand on a Zoom call for every parking ticket I got. If I have to go downtown to fight it, I'm going to say, to heck with it, I'll pay the $20. And obviously, so there's a barrier to me fighting my parking tickets, and there's reasons why that's got value. If we make litigation a lot easier, have you got any thoughts or responses to like that problem? If we make litigation easier, we're going to get more of it. And again, just like I like small government, I like small litigation. I like fewer fights in society. I like less litigation in general. I mean, I think guiding principle for always has to be, when in doubt, smaller government. It also has to be, when in doubt, less litigation.
Well, first, I'm here to take input, and I've written down the notes from yours and Representative Johnson's comments. And I think that, from my perspective, we're a service industry. We provide a service. People have disputes, and our job is to help them resolve their disputes. And so, just like, I'm pretty sure Amazon and UPS and FedEx are going to still be zipping all through our neighborhoods a year from now, just like they were last year. The courts have to take the best of what we've learned during the pandemic and move forward. And so as we balance off remote and person, I'm reminded as a district court judge in the middle of nowhere in Mason in Ingham County, Michigan, the lawyers that are in Kent County and in the metropolitan Detroit area are suing, let's say, on medical debt. And they file a motion for summary disposition because chances are really good the defendant doesn't have much of a defense or hasn't found a way to assert it. So what happens pre-pandemic is the lawyer in the metro area or in Kent County pays someone local $75 or $100 to come stand face-to-face with me and the defendant in the courtroom. But the lawyer who's standing there not only didn't write the motion or brief, probably didn't read the motion or brief, isn't familiar with the file, doesn't know anything about the medical debt, and can't settle the case. So the ability of that person to not be there, but the lawyer from Kent County or the metropolitan area to be able to be there on Zoom and say, I just want to talk to him. We haven't been able to get them on the phone. If they're there in the courtroom, we can make a deal. And what I'm hearing from my former colleagues is that is exactly what's happening, is that we've made resolution of people's legitimate justice problems easier. As a service industry, we are providing a better service.
Do you have a follow-up, Representative?
I do. So three things. First of all, happy to talk to you offline, and I know that Representative Johnson would be. So we don't need to wrestle about this infinitely in public. But I want to at least bring these things up. Second of all, Plato's old line that he only wants countries run by people who don't want to run it. You may be an example. You walked away from being a judge to do this work. So, I have a great deal of trust in you, let's be clear, and I also think you're almost certainly smarter than I am. So so I'm happy to continue to work with you on this. But But I don't know that you directly addressed our issue there. In other words, you said this will make things better. I have no doubt that permissive remote hearings will make things better. My question is, do we want to walk away from allowing participants to opt out of it simply because, absent a compelling reason, we all know that the gold standard for communication is face-to-face. We all know that it's not always necessary. That's why I have a telephone. A lot of times I don't need to see people face-to-face. But I think that there are reasons to think that even non-articulable reasons. I mean, our brains are full of a lot of things, some of which are analytic, some of which are emotional. My inability to maybe even articulate a reason why I want to see you face to face may not be sufficient argument to say that that's not necessary or not a good idea. In other words, if I want it, maybe it's worth paying attention to my want, even if I can't say why.
Again, I think it's valuable input, and I'm going to make note of it and bring it back to the court. And I guess from my perspective, that's why we have judges. We imbue them with that discretion to be able to determine what's appropriate thing to do next, and we do it in such a way that their work can be reviewed.
You want to go to the point, Representative Johns?
Very quick, if I may. What's your thoughts on what I suggested where if one person says, hey, I'd like to be in person, we do that, and then do that for 12 months and get the data and see, all right, how often is it being abused by one party or something? That way we could have something to look at instead of completely going away from that. Why not do a 12-month trial period, and then you can see, all right, this is being abused. We need to, in your opinion, go further. What about doing something like that?
You know, that was my instinct exactly. 2.5, 3 months ago, I provided a recommendation to the court that we do pilot projects so that we don't just have how judges feel about things and how lawyers feel about things, but actual data about how it worked. And as a result of this overwhelming public input, I don't believe that's what's going to happen next. However, whatever happened next, we're going to be collecting that data. You and I have had long conversations about our inability to collect data based on the case management system. You're going to help us fix that, and we're going to collect that data. So no matter what happens next, we're going to be doing that experiment that you've described.
Representative Mueller.
Thank you, Mr. Chair. Judge Boyd. Just a couple ideas, I guess, and some concerns I see with this. You haven't addressed anything to deal with like crimes with victims. You know, you have DVs, you have assaultive crimes, you know, you have the hearings, you have maybe the offender standing in the background leading to witness intimidation, that type of thing. I don't think that would be a very good avenue for victims, right? When they have the assailant sitting behind in the other room basically threaten them when they're doing remote hearings. And the decorum part too, you know, you have people half-dressed, flipping off judges, swearing at the judges where they don't have any recourse for their actions where they're in court. You know, if you tell a judge to fuck off, you're in the back sitting with the deputies, right? You're not, you know, getting muted on a TV screen. The other thing is with, you know, I could see, you know, with traffic fines and civil infractions, you know, creating some type of avenue for people because people do travel from the Upper Peninsula to the Lower Peninsula and vice versa. You know, I get a ticket up in Newberry in the Upper Peninsula. Do I really want to drive all the way back for a civil infraction? So maybe things like that to help, you know, people not having to travel back for minor traffic offenses, but not anything with like victims' crimes, you know, with, you know, crimes like, you know, speeding in a construction zone, things like that. We could maybe do those remote and also have, you know, the police officers being able to testify remote in cases of some juvenile hearings. So if, you know, a kid goes up to Lake Superior State, commits a CSC4, you know, and he's from Lansing, those officers investigating it up in Sault Ste. Marie are going to have to drive all the way down to Lansing, you know, especially after we raise the age. Now we have a whole nother group of people that are 18 visiting their kids at college. That could help out too with some of the timeliness, but I think we have to narrow our scope on this because of, like I mentioned, the decorum. You know, our courts have been around for hundreds of years, and it's supposed to be, you know, maintain decorum and respect, you know, to the bench and to the process. And the last concern is I don't want this to open the door to remove district lines. So then we have judges sitting remotely. You know, I don't want a judge up in Escanaba as a visiting judge determining a case in Livingston County when they have no idea about the community. They just are like, okay, well, I can be a visiting judge. I'm retired. I can be a visiting judge. I'm sitting up north, but I can hear cases down in Oakland County, Wayne County, Genesee County, but have no idea of the neighborhood, no idea of the people involved. and no connection to the community, making determinations for that community because they're supposed to be judged by their peers, not by a judge sitting up in Escanaba that might have a totally different view because he or she doesn't live in that community.
Thank you, Representative. Valuable insights, and I'm gonna make notes. Just a couple quick things. One of the reasons I was always for court consolidation of the district courts in Ingham County is because the way the lines are written, you often are in front of someone who you couldn't vote against. So I'm totally squarely with you on that last point. There's a company in Washington County named Matterhorn, you may be familiar with them, who we do online ticket resolution with them all the time. We've been doing that for not quite a decade. So the advent of a remote hearing, think about how many times people show up to fight their ticket just hoping that the law enforcement officer got called to an emergency and couldn't be in court because then their ticket's going to be dismissed. With remote hearings, the law enforcement officer can appear from anywhere too. So there's advantages all across. I never had a gavel. And people say, well, what do you mean? And I said, I just never had one. And they said, well, how do you keep people, people's attention, keep them in line, keep them behaving? I said, I found that if you talk nice to people, you don't need to pound wood to have them behave. Have people used the expression you use to me in court? Yeah, they have. And I didn't do anything. I've told them, you're having a bad day, but it's going to be okay. And, did I once have a mentally ill gentleman have to be wrestled to the ground by law enforcement? Yeah, I did. And they did a good job, and they were respectful, and he came back and apologized to everybody a couple days later. Courtrooms are kind of an interesting place. So decorum is a tough thing, and people who have learned how to use Zoom, and I'm going to admit I'm not a Zoom expert. I changed jobs the day the governor announced the stay-at-home order. So I haven't had big Zoom dockets like some of my former colleagues. But they tell me that they bring people in and out as soon as they misbehave. It's like, oop, you're out. Way easier than wrestling into the ground in the courtroom. It's pushing a button, and they're gone. And then they have to reschedule, or you send somebody to their house. I mean, my former colleague, Judge Donald L. Allen Jr. from Ingham County, he's had his sobriety court begin with calling Mr. Johnson, and Mr. Johnson said, I'm sorry, I've got to go, there's a knock on the door, and Judge Allen said, I bet there is. Because that was the sheriff coming to arrest him at Judge Allen's instruction. So, it's not perfect, but before it wasn't perfect. But I really do appreciate your thoughts, and I'm going to bring them back.
Really quick, and just with that, the one thing I see, and then I bring up, the Zoom, and then you can send it, to me, that's like an officer safety issue, because then the person, okay, you're going to get arrested, so then that gives that time for that person to prepare, so when the deputies or troopers or whatever come there, you could potentially have yourself a barricaded gunman situation because they're prepared and have the drop on it, and to me, it's not worth it.
He didn't know it was law enforcement. I totally agree with you. The last thing we want is the offender to know something law enforcement doesn't. That's why quick entry by courts and lien is so vital, because the individual knows that they're wanted. We need to make sure that law enforcement officers at the side of the road have that same information, and that's on us to make sure you have it.
One more question. Rep. Yancey.
Thank you. Thank you, Mr. Chair. Thank you, Judge Boyd, for your testimony. I obviously am a strong proponent of Zoom, considering that I do my hearings here on Zoom when I can. Woke up this morning nauseous and decided that I would stay home and participate in committee on Zoom. So I would like to commend the court and you as well, Judge Boyd, for moving us into the 21st century. Oftentimes we say that the law is behind science and technology by 20 years. And in this case, we are absolutely right. And so I commend you for moving us into the 21st century. I also, some of my comments were going to be some of the things that you actually stated yourself, which is we're not giving the judges enough credit when we're saying that body language is important. Absolutely, it's important. But we're not giving the judges enough credit when we say that they either may not be able to read body language, or if they pick up on certain things that they can't adjourn the hearing. And this is what I'm hearing from my judge friends. They adjourn hearings and say the next hearing will be in person. If there's a person who they think is being somewhat disrespectful, or if they think that there's some body language that they are missing, or if they think that the person isn't wearing a shirt, or whatever the may be, they are always able to reschedule those hearings to be an in-person hearing. So the next time you appear, you will be in person. And that time in the next go round, when they know that they're going to appear in person, they're there timely, and they're there appropriately, dressed appropriately and speaking appropriately. So I think that this is definitely a call that judges should be able to make when it's necessary to be in person and when it's not. And so far, I'm hearing, at least from my community, that it's working very well. Another reason is, like, when you have a defendant, and I'm talking about in criminal courts, where you have a defendant who doesn't have transportation, where we're trying to decrease, as far as the Michigan Task Force on Jail and Pretrial Incarceration, we're trying to decrease that jail population. This helps tremendously because you don't have, and I don't know, you tell me what the data shows, please, Judge Boyd, in terms of how many people are actually missing hearings and avoiding some type of bench warrant due to that.
Unfortunately, our current data systems don't allow me to answer that last question. I have some preliminary numbers. So through the Justice for All Commission that Representative Clement sits on, we're working with a consultant named January Advisors, and in the civil context, we have seen things like the default rate in landlord-tenant cases is down near 50%. The default rate in local or small-level collections is down. We are looking at the numbers to see how many, how the bench warrant numbers for failure to appear have changed, but I do not have that data available at this point.
Thank you.
Well, thank you, Judge Boyd. Thank you so much for taking the questions. Representatives, thanks for the conversation, and we hope you take some of our thoughts into consideration, and we'll probably follow up to learn more as this process goes through the court rule process.
Thank you for the opportunity,
So,
Mr. Chairman.
Okay. Thank you. I don't have any cards on that, and we are going to go to House Joint Resolution Q. This is Representative Aller raising the judicial age limit. And Representative, whenever you're ready, I appreciate you testifying.
Okay. Good morning, everyone. And thank you, Chair Filler, for allowing me to present this information on the resolution. This resolution, Joint Resolution Q, proposes an amendment to the state constitution to raise the constitutional age limitation for judges from age 70 to age 80, placing the question before the state's voters during the August 2nd elections. Michigan's Constitution currently states, "No person shall be elected to a judicial office after reaching the age of 70 years. For the individual who wants their name to appear on the ballot, this apparently means if that individual reached the age of 70 before the election, he or she would be unable to run for election. However, if that person attained the age of 70 one day after the election, then it would be acceptable for that individual to be on the ballot." This issue came to my attention during discussions I've had with those in the field of law, those serving, and others who have served. It was explained to me that many qualified and competent jurists have been pushed out for one reason. To put it simply, the year they were born. Were they going to be 70 years of age before the election? If so, they couldn't run. Their abilities and competence on the bench were not evaluated, only their age. In reviewing past actions within the state legislature, there have been similar attempts to address the age cap. I've been asked why I chose the age of 80, or why I haven't simply tried removing the cap altogether. Some examples of previous attempts here in the House include House Joint Resolution P of 2001 and House Joint Resolution S of 2015, which both proposed raising the cap from 70 to 75. However, neither made it out of committee. Our colleagues in the Senate have had better luck. Senate Joint Resolution F of 2013 made it out of the Senate Judiciary Committee unanimously, but was never given a vote on the Senate floor. At the time, Michigan State Court Administrator Chad Schmucker testified before the committee, saying lawmakers should consider raising the age limit instead of throwing it out completely. And the year before SJRF's introduction, the Judicial Selection Task Force, which had examined other state models, recommended the removal of the age 70 limitation. They said, and I quote, "The task force believes that this limitation is arbitrary in nature and serves no legitimate public interest." The report also said that doing away with it could increase the pool of qualified judicial candidates and ensure that competent judges are not arbitrarily dismissed from eligibility for reelection. As a side note, we don't see any caps put on other elected officials in our state. So here I am today, presenting a resolution that places the age cap at 80 years of age. This is based on input received from those in the field of law and summarizing, although briefly, previous actions by the legislature. I considered the aspect of lifting the cap altogether, or in fact doing nothing with the current cap. However, I believe Michiganders, judges, and the court systems are negatively impacted by basing a judge's expiration date in office as being based on age. One who has attained that age has many years of experience and wisdom, is capable of mentoring the newbie, so to speak, and has accumulated knowledge that only comes with time. To prevent a knowledgeable, capable, experienced jurist from sitting on the bench because of his or her age is a travesty and should be reevaluated. I do have an individual who is testifying on this joint resolution, testifying via Zoom. So I guess I'll just emphasize these limitations aren't imposed on any other elected office in our state, and we should allow the voters to decide whether this change makes sense and give them the opportunity to elect or re-elect those who they feel will best serve on the bench. Thank you.
Thank you, Representative. And I believe we have Judge O'Connell on Zoom.
Correct.
That's correct.
All right, Judge, go ahead.
Good morning. I've been listening here for the last hour, so I think brevity is the key to success in this proposition. So I plan to speak less than 5 minutes. My name's Peter O'Connell. 40 years ago, I was one of the youngest judges in the state of Michigan. But because of Constitution 1963, Article 6, Section 19, I was forced to retire. For efficiency through this process, I'm going to refer to Article 6, Section 19 as the 70-year rule. I want to thank Representative Eller for inviting me to speak today on behalf of this joint resolution. I know you're busy. I'll make my comments short. As I just said, the good news is my prepared remarks are less than 5 minutes. I've divided this presentation into two parts. First is a short history and the reasons why you should support this joint resolution, and also the history of this particular constitutional amendment. Feel free to interrupt me at any time I say something that you want to ask a question. I'm used to interrupting others when I was on the bench, so I have no problem with you interrupting me to clarify a point as we proceed. Before I tell you my top 10 reasons why you should support this bill, I want to tell you that the Judicial Tenure Commission is very effective, or should I say, extremely effective at removing judges who no longer are qualified to do the job. Most cases are resolved in a quick and efficient process. And my prepared remarks are divided into two categories: the history and the reasons why you should support this bill. Let me give you a brief history on what I call the 70-year rule. In 1835, Michigan had its first constitution. It was revised in 1909. Neither constitution had an age limit. It was amended in 1955 to include an age limit for judges, which provision was carried over to the 1963 Constitution. In 1963, the life expectancy was less than 70 years of age. Today, it's somewhere between 78 and 80, and many people live a lot longer than that. Today, 80 years old is roughly equal to 60 in 1955. Of import is that we went 120 years in Michigan without an age limit, and the judiciary survived, and so did your constituents. Okay, the following are 10
Hey, Judge.
important reasons why I believe
Judge, it's Rep. Filler. Can you hear me?
Constituents
Nope,
would
you
you
can't.
vote yes on this bill. I should note that everyone, sooner
that
or later,
Zoom?
will be impacted by a judge's decisions. Some of you already have experienced.
Judge, can you hear me?
Okay, I've just been unmuted, I think.
All right, can you hear me?
Yes.
All right, we have a question from Representative LeGrand.
So, Judge, I'm going to take you up in your offer to interrupt you. 3 questions. I think we could both agree that 100% of dead judges are no longer on the bench, right? So, so lifespan is really not the
I think
issue.
this is going to be a rhetorical question, yes.
No, so lifespan's not the issue, correct? Can you tell me, are you arguing that there have been advances in cognitive science that have been able to delay dementia, senility, Lewy body syndrome, or anything like that? Because I'm not aware of any, in which case lifespan is really not the issue, cognitive decay is the issue. Second of all, you said that the Judicial Tenure Commission is very effective. Can you tell me how many judges are removed on an annual basis by the Judicial Tenure Commission from the bench? And third of all, can you tell me in a cycle, in any given cycle, what percentage of incumbent judges lose elections?
Yes, 3 questions. First,
And I'm
I
sorry,
agree-
Representative Johnson.
I agree with you that cognitive abilities are the issue in this case. What I was referring to is the Judicial Tenure Commission's ability to remove somebody in a fast and efficient manner. And I also alluded, and I agree with you, Representative, that people are living longer, and the issue is the mental capacity of the judge. What I was trying to tie in, which I probably didn't do very efficiently, was that the Judicial Tenure Commission notices those people. In fact, I know 2 of them in my term on the bench that got a call from the Judicial Tenure Commission. They have a process. They have this process. They receive a complaint, either from judges or from the lay public. They immediately begin an investigation. When the investigation is done, they send the judge a nice little letter. And when you get the letter from the Judicial Tenure Commission, your stomach sort of goes down. You must respond to it. And generally, and here's the answer to your second question, and generally there's never any hearings. What happens is the Judicial Tenure Commission contacts the judge, they reach an agreement, and for some strange reason, the judge retires quickly. I've watched that happen to at least 3 judges now, where there was never a hearing. What you hear about is the contested hearings. And what I can speak to is the contested hearings, and there's only 2 or 3, at maximum 4 a year. The rest of them are handled confidentially by the Judicial Tenure Commission, and we never hear about it. Did I answer your questions?
Well, you didn't actually answer that question, because my question was how many people have been removed. I didn't ask how they were removed. So if that was one question. And the other question was, in a given judicial cycle, what percentage of incumbents lose their elections?
How many have been removed is confidential. We'll never know that fact because the Judicial Tenure Commission is a secret process. But I'll tell you, it's a lot more than you think. And the answer to how many judges lose in an election, I know one that beat the incumbent. That was myself back in 1978. And I've watched one up in the UP lose his re-election bid. It was a probate judge. When a judge is such a liability to the bench, and he hasn't been referred to the Judicial Tenure Commission, surprisingly, the people know that, at least in the local elections. And so while the odds aren't great to beat an incumbent, it can happen if the judge isn't doing his job and isn't competent. Now, did that answer your question?
Well, I guess it answered my question in the sense that you're asking us to make a policy decision based on no information. If we don't know how often, if it's a secret how often they're removed, then we're being asked to make a decision based on no data, which makes me uncomfortable. And the other was anecdotes, not statistics, with all respect, due respect. I mean, yes, I understand in the human history, judges have lost elections. My question is, I think that a lot of us up here are focused on data. What percentage of them lose is what matters to me. And, we can trade anecdotes. I mean, the two worst judges in Kent County, one of them mercifully had to retire because of the age limit. And the other one hasn't retired yet because he hasn't hit the age limit. But neither one of them, as far as I can see, were ever in any risk of not getting reelected.
I don't have the data and I can't provide it to you. So let's leave that question there. Any other questions on the Judicial Tenure Commission or any other thing at this time? Let me give you the 10 reasons why I think you should vote for this bill. First, it's clearly age discrimination, and age discrimination is morally, ethically, and legally wrong. Michigan Elliott Larson Civil Rights Act makes it unlawful to discriminate against an aged person. And I like to coin the phrase, old lives matter. Which includes some people who refer to me as being old, which I think chronologically I may be old, but when we go back to the representative's question, I'm still capable of doing the job. Second, allowing some judges to serve until age 76 and forcing similarly situated judges to retire at age 70 is incongruous, it's harmful, it's unfair, and it's simply wrong. By that I mean we have a great constitution that guarantees equality to all, and then for some reason it discriminates against senior judges. Clearly, it violates the spirit of the equal protection law. Third, the amount of knowledge, acuity, and experience lost in forcing good judges to retire at age 70 is a complete waste of judicial experience. Now, I want to, at this point, go back to the representative's question. Yes, there are people who think there are bad judges out there. Yes, there are judges who have ruled against people. Can we get rid of all of them? No. Are there the majority of older judges that need to be removed? No. Are there some? Yes, I've seen it. In fact, I'm aware of one that was just removed. Well, when I say removed, they're not removed. They voluntarily retire once there's been enough complaints filed against their judicial decisions. Okay, let me go on to 4. I want all of you to ask yourself this question. Whom do you want deciding who gets custody of your children, your assets, your business, your house? An experienced judge or a new person without any judicial experience? 5th, the 70-year age rule was made 60 years ago, prior to the time most of you were born. There's just many advances, and this is back to the representative's question, in medicine that allow people to live longer. It's time to update the law. Now, the representative stated that what's at issue here is acuity, the ability to do the job and get the job done. And I'll have to admit, in some instances, some judges have lost, as other politicians have, the ability to do the job at any level. And I venture to say this will eventually be put in front of the Judicial Tenure Commission, and the judge will be asked to retire. Judges are the only elected official in the state subject to the 70-year rule. No federal judges are subject to the 70-year rule, and they're doing just fine. 7th, my favorite justice is Judge Oliver Wendell Holmes. Most of you know that he was 90 years old when he left the bench. He's remembered for his concise opinions on civil liberties and his deference legislation. My screen is showing that I was just muted. Is there a question?
No, I think you can finish. Might have been an accidental mute.
Yep, a couple more minutes. Justices such as Ginsburg, Stevens, Kennedy, Scalia, and Thurgood Marshall, who was 82 when he retired, would be disqualified from serving in Michigan. I want to say, being a good judge is more than just plugging facts into a computer and getting a decision. It's a complex process gained through years of experience. The law of unintended consequences also applies to the judicial decisions as well as it does to legislative decisions. Experience allows you to avoid some of these pitfalls. Eighth, good old Ben Franklin was 81 when he contributed to writing the U.S. Constitution. So older judges have a contribution, and I think they're a valuable asset to the system. Ninth, this strikes home for most of the representatives. Age limits prevents the public from voting for the most qualified candidates. In my opinion, this is similar to term limits, which of course I don't favor. 10th, and finally, I prefer my judges with a little gray hair, a lot of wisdom gained from years of experience, both in life and on the bench. I think your constituents should also respect the fact that wisdom and experience is important. I want to thank you for having me here. I hope that you have some further questions that I can try to answer. Do any of you have any questions? And let me say one more thing. Generally, my experience is that a judicial committee, or the committee on the judiciary, has generally made up their minds before they appear in a public hearing, or at least they're leaning towards a particular decision. I'm going to ask you to vote yes on this, the 10 reasons that I've stated, because of the history, and just get it out of committee and let the people decide if they want older judges with experience, or they're worried, as Representative is worried, that some judges are too old to be on the bench. There's always a give and take in the legislative process. And at this point in time, I know many judges, as Representative Aller has said, that have left the bench because they don't have the proper age. They weren't born at the right time. In fact, one of my colleagues, Judge Jansen, birthday was the day after the election. She got 6 more years on the bench. And since my birthday was 60 days before the election, I had to leave the bench. In 2015, the State Bar supported the proposal, Judges Association and the task force all supported the proposition. All I ask is that you vote yes, send it to the full House, and let the House decide what's going to happen to the bill once it gets out of committee. Any questions?
All right. Rep. Aller, we do have a couple questions for you. And I do want to mention that where I'm from, a judge named Randy Tavonen was aged out by our Constitution, and he is, pretty much the base of judiciary knowledge in the Clinton and Gratiot communities, and that was a real loss. We're very thankful that he stuck around to mentor the incoming new judges, but that was not a good thing for administration of justice where we lived. So some real life experience. Rep. Johnson, a quick question.
Yes, thank you, Mr. Chair. Representative, I like most of the bills you sponsor. I think we're going to be opposing this one. I think the biggest issue deals with elections, right? Because your judges have this unique thing in Michigan where they have the incumbency designation, and that's why they very, very rarely ever lose. And most people don't even run against them because there's no point. The incumbency designation pretty much makes you nearly infallible to losing an election, and there's no term limits. And it was mentioned about talking about some of the Supreme Court judges at the federal level, and I think that's actually a good example and bring that here. We like to act like judges, there's no politics, whatever going on there. But at the end of the day, there is, especially at the Supreme Court level. And what would happen is the exact same thing as what we're seeing at the federal level, where you have Supreme Court justices staying on until they pretty much die because they want to make sure that their opinion can be there long enough, or they, all right, I got the right person in office now, so I'll retire, so then they can appoint someone there. And all of a sudden it becomes about these political games, and you have people serving on the bench who shouldn't be serving. They're well past their prime. There's 10 million people in Michigan. I think we can probably find someone who has that same wisdom and isn't just holding on to it for political reasons or for selfish reasons. So I think that's what I'd ask. Would you ever be in favor of, if you're going to do this, that you would remove the incumbency designation and put some other form of term limits on a judge so that way they couldn't serve indefinitely?
Excuse me. What I found very strange with regard to the law as it is now, the Constitution, as was mentioned by Judge O'Connell, somebody born a couple of days before the election couldn't have their name on the ballot. But an individual born the day after the election, turning 70 the day after, was able to have their name on the ballot. So that's what prompted, this bill. As far as judges being elected, reelected, and you're basing it on, the incumbency designation, I think it's up to the voters. Unfortunately, voters tend to not look into who they're voting for. They'll pick a name, and that's where that incumbency designation is coming in. Oh, this person's in office. Yeah, let's go for him. It still falls back on the voter to know who they're voting for, to identify what they like about this candidate or what they don't like. So it's the voters that are the ultimate decision makers. Personally, I don't care if the word incumbency is behind their name or not. So I would be open to further discussion on that. But it's important for the voters to have a say and to know who they're voting for.
All right, one more question, Rep. Yancey.
Thank you. So my question, did you consider, and I don't want to be insensitive at all, but instead of having the judiciary tenure review cases after several complaints, did you consider possibly having psych evals done after a certain age point in order to raise the bill or raise the age to 80?
That aspect is not, within this resolution. This resolution is strictly altering the number in in the state constitution from 70 to 80. Now, what you're bringing up, I think, would be more of, a policy decision. Somebody else introduce a bill, asking for that. Or even within the judicial tenure system. I'm sure they have their rules, administrative rules, policies. It might be something that they could look into on that end.
Thank you. And I do support raising the age. I think that we are losing a lot of institutional knowledge because of it. I know at least recently, one of my mentors, Cynthia A. Stevens, retired, and she is like a walking encyclopedia. I think that we are losing a lot by dismissing judges at that just because they were turning 70 when they still have a lot more life and a lot more sense than some of us younger people. So I appreciate your efforts.
All right, we have about 10 minutes left, and we have to do a couple things. So, Representative, thank you. No more questions. Thanks for bringing this up. First of all, we do have a little more testimony on this bill, but before we do that, I want to switch to House Bill 5749 and take that up for a vote. This is Representative Fink dealing with district court judges' pay parity. We took testimony 2 weeks ago. I don't know if I have any. I do have some cards. Bruce Timmons supports the bill. Jody White opposes the bill. Janice Daniels is neutral on the bill. All three of those individuals want to speak. However, we are short on time, and there will be, and I believe, Bruce, no. So I guess any follow-up on that will have to be presented to the committee individually. And, of course, as the bill moves through the legislature, we do have an amendment on this bill moving the effective date of the legislation from October 1st, 2023 to October 1st, 2022. And I'll take a motion. Oh, somebody's got to move that. Rep. Clements, thank you. And we will vote on that amendment that's properly before the committee.
Chairman Filler.
Yes.
Representatives Mueller,
Yes.
Griffin. Yes. Johnson,
No.
Colley,
Yes.
Rendon,
Yes.
Berman, Clemens,
Yes.
LeGrand.
Yes.
Yancey, Bolden,
Yes.
Hope,
Yes.
Green.
Aye.
Mr. Chair, you have 10 yeas, 1 nay, 0 pass. The amendment is adopted.
Thank you, Madam Clerk. And I will take a motion to report House Bill 5749 as amended as a new sub with recommendation. Rep. Breen, thank you. We'll take a vote.
Chairman Filler.
Yes.
Representatives Mueller,
Yes.
Griffin,
Yes.
Johnson,
No.
Colley,
Yes.
Rendon,
Yes.
Berman, Clemens,
Yes.
LeGrand.
Yes.
Yancey, Bolden,
Yes.
Hope,
Yes.
Green.
Aye.
Mr. Chair, you have 10 yeas, 1 nay, 0 pass. House Bill 5749 is reported with recommendation as amended as a new sub.
Thank you. Thank you, Madam Clerk. Now, we're going to return because we do have until 10:30, and I do want to give the chance for people to speak. Bruce Timmons, we're going to return to HJRQ. Rep. Aller raising the judicial age limit. Bruce Timmons has submitted a written statement and would like to speak. So we just ask that you give us about 3 minutes if you could. We do have the written statement in front of us, so. Oh, and I also want to put on the record that the State Bar of Michigan supports HGRQ in concept and does not wish to speak.
Thank you, Chairman Filler. My name is Bruce Timmons. I served in various legal and policy positions for the legislature for 45 years before I retired almost 10 years ago. The last 30 were on the staff of the House Republicans, covering what you folks with Cynthia and Catherine are doing now. I think one thing that I would respond to Judge O'Connell, who I've known for about 40 years, you would never have any new judges because the new ones aren't qualified. There is a need for constant turnover in all institutions. That's the premise behind term limits, although I think for the House and Senate is much too low. The age limitation basically serves as term limits for judges. Anecdotally, I've known situations of the judges who stayed too long. They had the designation on the ballot. They were never challenged. And one thing I need to correct Judge O'Connell on is there were times where the Judicial Tenure Commission did exactly what he said. That's not happening right now. Judicial Tenure Commission has been understaffed and underfunded for the last several years. They have a serious backlog of a couple of years of pending cases. I helped draft that constitutional amendment as an intern. I followed it very closely. There have been 2 attempts where judges tried to limit what the Tenure Commission could do. I am very nervous about extending the age. The age as proposed would also allow the same type of thing that is talked about in regard to 70 of the age. You just change it a decade, and you're going to have people who will be on that bench to age 86 or 88. And again, difference between what happens in the federal system, where there is a vetting of the judges. You don't really have that in the election system with the incumbency designation and with the lack of competition because of that. There are examples that we all know. I've been around long enough to know a number of judges and justices who had to retire. They were exceptional people, and that's the point. They were the exception. I have a lot of friends who are contemporaries of mine, which means we're all reaching near 80. Most had health issues by 70. It wasn't so much mental, it was physical. They simply couldn't do the work the same level that we used to do when we were younger. That's one of the reasons I retired. So I think it's not really broken. I would not suggest fixing it. Thank you.
Thank you, Bruce. I appreciate it. All right, next we have Jody White and Janice Daniels. Jody opposes the bill, Janice is neutral, and they would like to speak for 2 minutes. So maybe they could come up together, if it's all right. And just know, we got that 10:30 hard stop, so just be succinct. Thank you.
Thank you so much. I actually want to thank public functionaries Aller.
I'm going to need you to turn on your.
Yeah, all right. I didn't know I had to take care of that myself. I actually want to thank public functionaries Aller, Kara, Filler, and Yancey for introducing this House Resolution Q, because it brings to light some really important, natural, yet missing requirements, not only for judges and justices, but for public functionaries in all three departments of the government at all levels. I personally wouldn't be opposed to increasing the age limit for anyone occupying a de jure office, because I think there is some wisdom that can only be gained through years on earth, but that's only as long as there are some requirements, and I'd like to suggest three of them. One, all public functionaries in all three departments at all levels of government, irrespective of their age, should be obligated to take an annual cognitive test to determine their ability to think rationally. Number two, all public functionaries in all three departments at all levels of government, irrespective of their age, should be required to take an annual drug and/or alcohol test. Number three, all public functionaries in all three departments at all levels of government should be required to obtain annual training, testing, and certification of their understanding of our Constitution and of their own limited delegated authority. I would ask you to please include these checks and balances in this resolution before it's voted upon. Thank you very much for your time.
My name is Jody White, and I have been an advocate for the probate court system for 4 years because there are some wrong decorum going on in the courthouses. So because of that concern, I'd like to come, and I do want to really thank what I heard today. I feel what happened to us in 2017, 2018, 2019 is being handled by our House representatives. And what my concern is I do not want the ages of the judges to be replaced, because the man that was just sitting here made a very good point. We have our complaints in with the JTC, and we have yet to get anywhere, but we just find out that there's no money to do it. But if we have the evidence, because we are allowed to record how the judges treat us in court to show where the decorum might be, the misconduct might be, the judicial canons must be a positive force for we the people, because public scrutiny is important. And as an advocate for other families that have been harmed, I do believe we need the open camera system. We need this gentleman that was Mr. Boyd, who was our public court administrator. Maybe he can be over 70 and they can take the job there, and the wisdom should go at that point. So the representatives that have spoken today, thank you very much. I do believe you are speaking the voice of the people, and we are looking for this to not end up on the ballot, because we'd like to see the 1/3 plus one who will be voting, because I would also like that vote like the judge wanted. He wanted a directed verdict by you guys to pass it. I'd like a directed verdict to not pass it. So whenever we can get to that, the better, because I don't think we need it on a ballot. Thank you.
Okay, thank you. Judiciary Committee, we're adjourned.